we've got. Were you to succeed on any of your grounds of appeal, what do you say would follow?
We would ask for the place of supply issue and any consequential matters flowing from that to be remitted for determination by the FTT. Obviously bearing in mind the Upper Tribunal has ruled that issues to do with the quantification of Sintra Essays assessment are to be remitted. The issue of control of Sintra Global has been decided by the FTT, so we do not submit that issue needs to be resubmitted. But obviously, if the matter were to be remitted to the FTT and we were to be successful on place of supply, there would then be consequential issues in relation to each of the penalties to be determined. We submit it should go before a newly constituted FTT. We made these submissions to the Upper Tribunal with respect of the issue of the quantification of the penalty, and our submission was reasonable perceived unfairness, relying on Lord Justice Voss's decision in HCA International. But we were concerned with the robust nature of the criticisms of Officer Foster, and I can make some submissions on that if I need to, either now or in reply. The Upper Tribunal's decision, which isn't in the bundle in that regard, refused that request, but the primary reason we would submit was that because the remission on the quantification issue was just to apply the correct legal test, not to reopen, not to look at factual matters. So of course, if you were to if this appeal were to be successful and you were to resubmit the place of supply issue to the FTT, because of the nature of the matter and it being the burden of proof, one would envisage that would have to be a rehearing of the facts in relation to that issue. And because it does involve an opening up of the facts and the witnesses, my application would be for a newly constituted FTT, and either now or in reply I could make brief submissions on why we say we make out that HCA reasonable perceived unfairness test for a different tribunal.
Well, that's very helpful. Thank you very much. I'll leave it there, and you can come back to it in reply should that be appropriate.
Great.
Mr. Webster.
My Lord, perhaps I can deal with that matter while it's fresh
Yes.
in my mind. The appellants did not appeal against the decision of the UTT that the matter should be remitted to the same constituted first-tier tribunal. This case lasted certainly over 3 months at first instance. The fact that the tribunal found the evidence of in the approach of the principal officers to be unreliable is, we would submit, not a sufficient matter to disturb the decision taken by the upper tier tribunal. I understand that these are different grounds of appeal in terms of what has to be dealt with by the Court of Appeal today. But nevertheless, where in terms of expense, etc., we've had such a lengthy hearing, it would be contrary to the overriding objectives, which of course bind the tribunal and this court as far as dealing with matters expeditiously, etc., are concerned. So we would submit, if it is to be remitted, it should be remitted to the same tribunal who are fully grasped of the issues and understand what the case is about.
One thing I certainly haven't checked is whether the members of that tribunal are still sitting. But
I think Judge Brooks is.
yes, I see.
So we could make that inquiry.
Yep.
So
but obviously, you say we don't never get to that point, so
No,
I ought
of
to
course.
let you develop those submissions.
Of course, yes. Can I start out by saying that I propose to address grounds 1 and 2. I'm going to ask my learner from Mr. Gurney to address ground 3. And having listened to the way in which the case has been put by the appellants and how the arguments have developed, can I start off by putting out our broad submissions before going into detail, and I hope making them out. Obviously, we hope to show that as far as the burden of proof is concerned, that the decision of the first tier tribunal, and of course it's the first tier tribunal's decision which has to be considered rather than the upper tribunal. I think we've referred to the case of Procter and Gamble. I'm not going to take you to it, but the focus has to be on the original fact maker's decision, fact finder's decision. So firstly, the decision on the burden of proof was correct. Secondly, that the guidance given in various judgments by the European Court of Human Rights, and indeed the various cases in the domestic courts which have been cited, has been taken out of context by the appellants and misunderstood. And that if we look at the various cases cited, we can see that what we call, and this is a phrase I'll be coming back to on a number of occasions, I fear, the foundational facts. The foundational facts required to be proved before any burden can fall on the taxpayer. So when one's talking about reverse burdens in these contexts, whether statutory or otherwise, one is starting from a point at which there's a necessary factual underpinning which has been proved by HMRC. In addition, we submit the statutory provisions themselves creating the penalties cannot sensibly be read as imposing an initial burden on the taxpayer. We'll look at those and see precisely what they say. We say also the decision that the burden of proof was upon the revenue conforms with what HMRC itself made clear prior to the introduction of the Finance Act 2008, that it conforms with HMRC's own manual of guidance to its officers, and that it conforms with concessions made by Revenue and Customs post the judgment in Khan in two cases before the tribunal. And one can't simply say, well, it was council that made these concessions. Council, of course, are instructed and usually have quite a number of people from HMRC with them. So those are our broad submissions in relation to the burden of proof. As far as ground two is concerned, this question of severability, etc., and having a particular order in which decisions should have been made, this was not raised before the FTT. And we submit with good reason. The arguments which have been advanced have an air of unreality. They're divorced from how the appellants conducted the case before the first tier tribunal. And although my learned friend said, quote, it's unheard of for a liability appeal to be subsumed in a penalty appeal, that's precisely what HMRC asked the first tier tribunal to do in this case. And we'll look at the relevant passages from the decision and the underlying documents to make that out. So the starting point, as far as matters of principle is concerned, is to note what is obvious, that this appeal does not concern tax assessments. It relates solely to penalties. However much the appellants have resisted this proposition over the years, it's now clear and accepted by them that penalties engage Article 6 of the European Convention of Human Rights. Obviously, in relation to this case, and the burden of proof issue, Article 6.2, is central, and we'll seek to identify the questions which the court has to address in any given case. And it seems clear from what, for example, Lord Bingham said in Sheldrake, that the questions and the answers may differ according to the individual cases. In some ways that's regrettable, because it'd be very nice to have a general rule that everyone could recognise, rather than having to go through the rigmarole of citing a large number of cases. But if it's understood that each case has to be addressed in its own context, that is an assistance to understanding what the European requirements are. So, in carrying out a review of the cases, it is, we submit, important to understand what was and was not in dispute, so as to understand the context in which various judgments were made, guidance given, etc. Because when we look at them, we'll find that almost without exception, the foundational facts were either admitted or proved. And the question of the burden of proof on the taxpayer was a subsequent issue. So if I can identify what the case was about in the way in which the revenue put it in front of the first tier tribunal. Because the reality of how it's put has been rather underplayed by my learned friend, calling allegations of fraud, etc., the background, but they weren't. Throughout the pleadings, throughout the witness statements, and throughout the conduct of the case, the appellants repeatedly alleged that Mr Malde was the principal orchestrator of a massive alcohol importation fraud. It was unequivocal, their case, and they sought to hold him accountable for that by alleging that two companies smuggled alcohol into the UK, Sintra, which of course we don't directly concern ourselves with in this appeal, and Global. Because they seek to finesse this in their submissions and their supplemental skeleton, it's worth getting some flavour of the way in which the case was conducted from the outset. Can I take you please to Call Bundle 277? And take to paragraph 513 of the FTT's decision. Talking about the High Court proceedings in terms of the freezing order, the particulars of claim issued by HMRC in those High Court proceedings in relation to the freezing order made its place explicit, stating, quote, Mr Malde has set up a complex web of companies to perpetrate the alcohol diversion fraud. His involvement in the central pillars of these frauds, namely Sintra and Sintra Global, Corktech, Park Royal, Brunel Freight and Amper, reflects dishonesty on his part. And then the principal prosecution, I shouldn't really have said, the principal witness for HMRC from his witness statements, and again, this simply reflects the way in which the case was put. Mr Malde has shown scant regard for his legal obligation to account for taxes on the sales of alcohol derived from the activities of the Sintra entities, by both failing to register the VAT, declare and pay excise duty, and failing to produce and submit annual accounts, and to account for corporation tax on any of the profits derived from the operation of the Sintra companies. Mr Malde was in control of both Sintra entities and also Corktech. Corktech was only used when a load was stopped and the load became the cover load. Any loads that got through undetected were effectively smuggled by Sintra. They may or may not have gone anywhere near Corktech's premises. And so that approach was not deviated with at any stage. and therefore to describe it as background is misleading. It's the way in which they sought to prove the case. They sought to prove a failure to register, they sought to prove liability, they sought to prove a failure to pay VAT and duty on the basis that this was a fraudulent operation, no more, no less. The way, moving on then to the question of how the tribunal was asked to approach its tasks, was very different from the way in which it's been analysed in these proceedings. Can I take you in that same core bundle to page 176? So having set out the various penalties against which appeal was made, the tribunal recorded what it was agreed were the issues in the case. Whether Mr Malde, this is paragraph 4, was the controlling mind behind SA and Global, whether SA and Global diverted alcohol into the United Kingdom and sold the stock in the United Kingdom, thereby giving rise to VAT and excise liabilities. Just pausing there, that was the foundational fact we say had to be established. It's not disputed that SA and Global were not VAT registered, etc. Then the quantum and whether there was a failure to issue a PLN in time. If we go on to page 293 of the bundle, the tribunal went on to consider the order of issues, and this has been read to you. I simply make this submission, that it's quite clear that the only submissions made by the appellants which were contentious vis-a-vis the submissions I was making was whether the question of control should be decided before a place of supply. There is no suggestion at all that the issues could be severable, and indeed if we go to the supplementary bundle at page 60, we can see precisely why the first tier tribunal had expressed itself in the way it did.
Sorry, hang on. I haven't put up.
Sorry, supplementary bundle, page 60.
60 or 70?
61 actually. Sorry. So this is a document that the parties were asked to produce to identify what issues the tribunal was going to be asked to determine, and then in a subsequent part of it, the agreed facts. So this is an agreed document, and the issues in dispute, which had to be resolved by the tribunal, are set out there, and they're exactly the same ones which they had already referred, or in due course, they referred to in the passage I've read out to you from their decision. But it goes further than that. If we can go to page 111 of this same supplementary bundle, which are supplementary submissions made by the appellants, those saying 4 issues are identified at paragraph 3. And then finally, in terms of the way in which the matter was left by the appellants with the tribunal, we go to their closing submissions in the same bundle, please, at page 175. But they say this: whilst there are 6 live appeals, HMRC submits the 6 appeals revolve around 3 factual issues. Whether Mr Malde was the controlling mind behind Sintra SA and Global, whether Sintra Global diverted alcohol into the UK and sold the stock, thereby giving rise to VAT and excise liabilities, and quantum. If all 3 questions are answered in the affirmative, then all 6 appeals should be dismissed. Of course, during the earlier pleadings, what the appeals were was identified just in the same way that the tribunal set them out. But it's quite clear from these extracts, this certainly accords with our lively memory of these 3 months we spent in Rosebery Avenue, that this was the way in which the case was conducted. And that there may be good reason for it when we come to consider the possibly different burdens of proof according to the statutory provisions, etc. And so the suggestion that matters such as liability to register are separate matters which are always dealt with first and then passported, whatever that means, those suggestions do not bear scrutiny. It certainly not occurred to the appellants at the time of the trial. It's also worth noting, when considering the burden of proof, that the appellants accepted without demur that they should go first. So if I can take you back, please, to the core bundle, to page 176. At paragraphs 2 and 3, we've looked at this before, but just to remind the court, a number of different acts and different provisions were engaged, and in particular, and although we're now concentrating on global, as far as Sintra SA is concerned, it and its liability was an important part of the proceedings before the first tier tribunal. If we look at 3.4, we can see that the director's liability notice issued against Mr Malde was issued pursuant to section 61 VATA, making him liable for the civil evasion penalty under section 60, and we've already looked at where the burden of proof in relation to those specifically by matter of statute is. But just to underline it, if I can take you please to the authorities bundle, page 51, which is behind divided 7, tab 7. That is the provision in relation to the liability of the director. And if we go to page 50, we see that the liability of the company on which the liability of the director is predicated, we see specifically where the burden of proof lies in relation to dishonesty. And of course, this section was used in relation to Sintra SA because they were going to be out of time, as I understand it, in relation to Schedule 21 or 24 penalties. So, one of those broad submissions was that an imposition of a burden of proof upon the taxpayer in relation to the foundation facts of liability was not compatible with the statute provisions which create the liability. Their wording we submit is important and has consequences in relation to what the exercise of HMRC and the exercise of the tribunal is. We will examine in due course the history of the measures. For the present, we need to look at the wordings. And if I can take you to the authorities bundle.
Just before you do,
Of course.
you've taken specifically to paragraph 3, 4 and the notice relating to Sintra SA.
Yes.
Then you took us to the provisions. What should I be taking from that?
Taking from that in relation to Sintra, under section 60 and 61, there was an express statutory burden to prove matters of dishonesty.
And that's obviously true. What do you deduce from that in
Well,
this context?
I deduce from that there were good reasons. Paradoxically, the position of the appellants in the first tier tribunal was that the taxpayer bore the burden of proof from start to last on everything. But clearly we did not agree with that, and therefore there was good reason why the best way to approach the case was not to atomise it in the way the analysis put forward by the appellants now is, but to look at those factual questions which would determine all the issues. So I'm simply underlining there may be good common sense reasons for that because of the shifting issues involved and the shifting statutory provisions.
Yep.
So if I can take you to page 96 in volume 1 of the authorities bundle, which is behind tab 13. We have the statute creating the ability to levy a penalty in relation to errors in taxpayers' documents. And we submit that the way in which this is set out is important. A penalty is payable by a person where he gives HMRC a document of a kind listed in the table below and conditions, we underline that word conditions, conditions 1 and 2 are satisfied. We submit that cannot reasonably be viewed other than setting out a precondition that a state of facts exists. And it's important to note that it's not expressed as being in the view of the commissioners that this state of facts exists. It refers to an objective state of facts. So before any penalty can be imposed, it is necessary that 2 conditions are satisfied. And we submit it's very, very difficult to see how that can be read as suggesting that somehow it's not for HMRC to show that those conditions are satisfied. And similarly, if we look at Schedule 41, page 175, in that same bundle, it's behind tab 14. We see the way in which, again, it's slightly different wording. It's a different act, of course. It's the 2008 Act. But a penalty is payable by a person where the person fails to comply with an obligation. Again, it's describing a state of facts. And we say that the existence of that state of facts can only sensibly be reviewed and could certainly not pass the muster under Article 6.2 unless it's viewed as a foundational state of facts which have to be proved before any of the other subsequent issues can be addressed.
Now, just seeing how far one can go, I mean, I'm quite follow you're going to come on to Article 6 and
Yes.
all the rest. But if you took an ordinary taxing statute, it would say tax is chargeable in a particular situation. Nevertheless, it is the case that the taxpayer, when assessed, appeals, and the burden is on the taxpayer. So what can you get out of the wordings of these things as opposed to the wider context? I mean, it's true, a penalty, you can do, a penalty can be imposed in a particular situation. Tax is payable in a particular situation. I don't quite see why the wording tells you whether or not the burden of proof is on one side or the other.
Because the wording we submit and the way it's expressed is unequivocal, and we'll go on very shortly to see that was precisely what the government said the provisions meant.
And I mean, it's obviously true. You can't levy a penalty unless there is an understatement or whatever,
Yes.
and the inaccuracy was careless. But that doesn't tell you where the burden of proof lies on anything, on the face of it.
Well, we submit that taking that and looking at Article 6.2, it's simply not possible to read obligations as to where the burden of proof lies consistently with Article 6.2, given the wording of the statutes.
I may have misunderstood Mr. Hayhurst's submissions, but my impression is, I mean, he's not disputing that the revenue need to establish the basic set of facts
Yes.
which justifies the imposition.
Well, we understood exactly the contrary. And it is important because when we look at the authorities, in every case that we've identified, the underlying facts either aren't in dispute or have been proved before one goes on to look at burdens of proof. But we agree that what HMRC had to prove in this case was that at some stage Sintra supplied or held duty-bill goods in the UK.
Yeah.
That's the starting point. They say we don't have to prove that. That's their case. We don't have to prove that because it's all very difficult, because the taxpayer has the information, etc., etc., and therefore it's reasonable to put the reverse burden of proof on those foundational facts. That is their case.
Mr. Webster, can I ask you this? Suppose there had been no penalties imposed.
Yes.
And this was a straightforward tax appeal. So assessments are made, taxpayer appeals. What would your submission then be about who has to prove or disprove the existence of the foundational facts, as you call them?
Yes. Well, we should say as a matter of ordinary principle, setting aside issues of question or reasonable excuse or the other things that one can pray and aid as far as reducing or obliterating an assessment is concerned, and accepting that Article 6.2 doesn't apply to pure assessments. Nevertheless, we would submit, consistent with our reading of the underlying statute in relation to these particular issues, it would be on HMRC. But it's very difficult, because what I've done is I've looked here at the way in which the statute has created penalties and the words it's used. I've not examined the wider issue of pure civil assessments, because the authorities seem to be reasonably clear on that.
And what do they say?
They say that the burden of proof then is upon the taxpayer.
Yes, complete opposite.
Yes, and with the caveat that if HMRC pleads fraud, there's an evidential burden upon them then to make it out.
And there may be special provisions if the assessment is out of time.
Yes.
Trying to
Yes.
dial an extended time for something like that.
Indeed so, but I don't have to argue wider. I understand why examining the proposition may throw some light upon the central submissions, but I am principally concerned with Article 6.2, but the nature of the provisions themselves. And it was certainly the view of the government when these provisions were introduced, the burden of proof, as far as penalties are concerned, would be upon HMRC. And it can't be narrowed down to situations of fraud, etc. It applied generally. So if I can take you, please, to volume 4 of the authorities bundle. Page 1207, which is behind tab 63. My learned friend took you to one or two of these, but didn't take you to, by all means, all of them, and perhaps didn't take you to the most important ones. But we can see the introduction. It's a consultation document from the 10th of January 2008, modernising powers, deterrence and safeguards. And if we can go to chapter 3, which starts at page 1213, we can see paragraph 3.1. This chapter outlines the penalty regime enacted in Schedule 24 of the Finance Act 2007. Chapter 4 considers how it may be extended to a number of other taxes. A single penalty regime for incorrect returns replaces several different penalty regimes. And if one then goes to paragraph 3.13, the document describes ways in which people may make inaccurate returns and so forth. In terms, there's a right of appeal to an independent tribunal against the imposition of the amount of any penalty. The onus of proof would be on HMRC. If we go then to 525, which is at page 1229, dealing with failure to notify penalties, failure to notify due to be payable, or failure to notify that VAT would be payable or register.
Sorry, could you just repeat that reference?
Yes, it's page 1229.
1229,
229,
thank you.
and it's paragraph 5.25. There will be a right of appeal to an independent tribunal against the penalty and its amount. penalties of deliberate failure to notify, the onus would be on HMC to demonstrate the behaviour to a high degree of probability. This goes rather further than paragraph 313 because it's talking about the upper echelons of culpability, as it were. And when my Lord Justice Singh was asking about standards of proof rather than burdens of proof, it's clear underlying this inevitably is that for the lesser aggravated forms of failing to notify, the standard of proof is regarded as lower, but there's no suggestion, there's no burden of proof. And we will look in due course at least one case in which the question of the standard of proof was looked at in significant detail in relation to penalty appeals. And again, there was no suggestion, it's impossible to reconcile the discussions with an underlying assumption that there was no burden of proof upon HMRC.
On your submission, what does the following sentence mean? Other failure to notify, the onus would be on the taxpayer.
To displace the penalty as now. I'd like to be able to answer that question. But the pre-existing regime, and again, we'll look at in the light of Hahn and the report which led to the alteration of the regime from a criminal regime to a civil regime, dealt with that, and perhaps I can deal with that when we examine that. If I may.
Sorry, go on.
So, and just before you go on, I mean, reading those two sentences one after the other, it doesn't look as though a clear distinction is being drawn between penalties for deliberate failure, where it's common ground and is accepted by Mr. Hayhurst that the burden is on the revenue to establish the deliberate nature of the failure on the one hand, and then other failures to notify penalties. Whatever that exactly means, but does appear to be looking at all other types of penalties, which might be an issue. The onus will be on the taxpayer to displace the penalty as now.
Of course,
against you.
yes, on the facts of this case, it doesn't matter.
No.
Because it was 100% liability, which is predicated upon that that aggravated form of liability. Do you excuse me? Again, looking at that paragraph as a whole, it considers also the suggestion is that grounds to displace a failure to notify penalty should be through a reasonable excuse provision specified in law, which would also form the grounds of appeal to a tribunal. So that would be a putting of the burden. Start looking back to paragraph 525 on the taxpayer. And then that's examined in the underlying paragraph. A reasonable excuse provision is an essential safeguard for any penalty where the underlying behaviour is not considered before a penalty is charged. Both Inland Revenue and Customs had separate and slightly different provisions. It's vital this safeguard remains that it's both clear and accessible. Reasonable excuse therefore appears to be a strong candidate for a single legislative provision across HMRC. Penalties for failure to notify would be the first occasion when such a reasonable excuse provision might apply.
This is a consultation document.
It is.
Obviously, it was intended to set out a fair and accurate summary
Yes.
of the current state of the law and
Yes.
so on, but it's not to be confused with a piece of legislation.
No, it isn't. And of course, the chapter 3, which we looked at before, describes what the government says is the effect of the 2007 Act. And makes it.
And there's been no challenge against the assessments on the basis that they're unlawful on public law grounds.
No.
Failure to treat taxpayers fairly or improper departure from previous assurances or anything like that.
Well, no. In fact, because there's a remedy of appeal provided to the first-tier tribunal, the basis for saying there was no adequate alternative remedies would be rather difficult to maintain. Can I then take you to the guidance which HMRC has issued? Again, it's in the same volume, Authorities Bundle 4, 1202, which 1203 is behind its tab 59.
I'm not sure mine's come out properly, has it?
If we ignore the tabs, it's page 1202. I think that
I'm afraid something I think has gone wrong.
so it's tab 58, in fact, rather than 59.
58.
My fault.
Yes.
So this is the HMRC inquiry manual, which of course is used by all officers as telling them how they must proceed. So page 1201, penalties, introduction, any form of penalty determination can be appealed. Starting second paragraph. Any appeal against a penalty assessment or determination can be reviewed or appealed to the tribunal in the same way as an appeal against assessment of tax. Unlike a tax appeal, however, in any penalty appeal, the onus of proof is on the HMRC to establish the penalty, not on the taxpayer to displace it.
Whatever Mr. Hayhurst may say this means, you're obviously not construing the legislation. This is something that goes to officers. You won't even be concerned with the fighting out of the appeal in a tribunal.
Well, we'll see the next page we look at does involve the tribunals. But no, it seems to us legitimate to examine what the government said about it, what HMRC understands it means and has said in writing it understands it means, and judging whether or not the submissions being made are substantiated.
There's lots of authority from the Supreme Court and elsewhere on when material like this is even admissible. The primary task of the court is to construe the legislation as enacted by Parliament. It's very important that the executive, for example, should not be able to set up what constitutes the law of this country, because that's not what Parliament has enacted. They can say all sorts of things. They may like to say things that are in their favour. That's not the law.
Well, my lord, as a general proposition, I agree. Of course, the contra profferentum, one might say, applies to this. But there are a series of them, all to the same effect. My learned friend cited some, and I'm just responding to that. But I'll just, if I may, confine it to one more. Because if you look at page 1203, which...
I think this is where it has gone wrong.
Well, I don't even have the page number, I'm afraid.
Right, well, it's appeals guidance, tab 59. It should be headed Appeals Review and Tribunals Guidance.
I'm afraid ours looks like this.
Yes.
So we haven't got any relevant words.
Right. Does it not have a second page with it?
No.
Well, I have a heavily truncated page which has about half of each line of text, or a bit more. Obviously, it's incomplete, I'm afraid.
And the
Well-
same applies to the next two tabs, I think.
Well, that is indeed unfortunate.
Or the next three tabs, actually.
We will obviously, between us, provide copies. Could I just very briefly explain what this would be if you could see it? Hearsay of the worst sort. It's talking about how officers should plead the case in tax appeals. And it says as follows: HMRC's case, the statement of case should set out HMRC's arguments. For example, HMRC maintain the tax is due because ... Should also refer to the customer's arguments and explain why HMRC considers them to be wrong, and then this. The statement of case should also say on which party HMRC believes the burden of proof rests. For example, in the case of penalties, the burden is on HMRC to prove that the penalty is due, while in assessments or amendments, the burden is on the customer to prove that the amount of assessed tax or profits is wrong.
So did the statement of case here say where HMRC thought the burden of proof lay?
Yes. And said in the case of penalties, the burden is on HMRC to prove the penalty.
But there were statements of case in this litigation, presumably.
Yes.
So did HMRC do that?
Yes, they said the burden was upon the taxpayer in relation to everything.
Yes, I see.
Which was why they were content, I suppose, to approach on the basis, find following facts, and everything else follows.
Do we have a copy of one of those statements of case saying what was the case that was being advanced by HMRC? Or
We do, I believe it's in the supplemental bundle. HMR's opening submissions.
That wouldn't be the statement of case.
Statement of case at page 4.
Yeah.
I'm going to have to scroll through it to find the relevant.
This is a supplemental bundle. Yes, I see.
Yes.
So this is just for one appeal.
And that's for the liability to be registered appeal. It's not.
No, it's for all of them. I believe so, yes. Oh, sorry, it refers to all the others. If we look at linked and related proceedings at page 7, it sets out all of the various ones.
Yes.
I'm just trying to find a reference to burden of proof.
Okay, but I mean, this actual statement of case is just about liability to be registered. That's all.
Yes.
My lords, just to assist, it was the burden of proof our submissions was made clear in our supplemental opening on page 113 of the supplementary bundle, paragraph 5.
So just to be clear, whatever the manual or whatever might say, the statement of case did not identify where the
From recollection,
burden
the
of proof
statement
is
of case
thought.
did not mention the burden
Yes, I
of
see.
proof. It
Yeah.
was in our supplemental opening, paragraph 5, which can be found in supplemental 113.
Yes, I see.
And said in terms, the burden of proof clearly lies on the appellant taxpayer with respect to all matters, liability and quantum. So we'll obviously have to examine whether or not that passes muster.
I mean, what obviously is admissible, at least within limits, is explanatory notes. I don't think they're helpful.
Yes, if we can look at page 1236 in volume 4 of the authorities bundle. So we have a number of paragraphs here. First, paragraph 1 summarises where penalties may be imposed.
Yeah, I'm sorry, I'm just getting lost again. Please, can you tell me where we are?
We're in authorities bundle 4, divider 64.
Yeah, and these are the explanatory notes for what?
The 2007 financed
Thank you.
bill as it then was.
Yeah, thank you.
you'll see paragraphs 3 and 4 refer to the conditions which I've drawn your attention to. Paragraph 10 defines 3 categories of behaviour rise to penalties: careless, deliberate but not concealed, and deliberate and concealed.
And these just restate what we see in the legislation.
Yes, yes. Paragraph 15 describes what the overall purpose was, the definitions of behaviour designed to replace the current concepts of misdeclaration, repeated misdeclaration, dishonest conduct, unreasonable excuse in relation to accuracy of VAT. For direct taxes, they replace fraudulent and negligent conduct. The uniform language for behaviours, but it doesn't deal with the burden of proof. If we go to page 1249, which is further into the same document, look at paragraph 33. We see it described as important safeguard for the operation of penalties, the right of persons to be able to appeal to an independent tribunal. Provisions continue and make more explicit appeal rights in existence under the current penalty regimes. And if we may, we'll come back to this later on when we look at the previous regimes and see why they were reformed and the way in which they were reformed. So going back to the issues in this case, it's common ground that unless supplies were made or duty-bill goods were possessed in the UK, no duty point could arise and no vatable supply could be made, and therefore no obligation to register for VAT. When we come to look at Article 6.2, important facts we submit, amongst others, are that firstly the penalties reflected in the personal liability notices against Mr Malde, who of course was not the taxpayer, total £34.7 million. And of course, when one is talking about the importance of the case and the importance of collecting tax, it does actually cut both ways. That an imposition of penalties of over £30 million on an individual is far more draconian than most things you'll find in the criminal courts. And secondly, in terms of Article 6.2, these aren't exhaustive by means, was that the first tier tribunal was invited to make findings of fraud with consequential reputational damage, which that would entail. So we deal in our skeleton argument, I'll come back to it, and what we say are the relevant factors to weigh in the balance in deciding whether it's appropriate to derogate from, for want of a better term, the Article 6.2 right and transfer the burden of proof. But these are two pretty important components of it we would submit. So, where does that leave us? On the issues in this case, as presented to the first tier tribunal and reflected in its findings, we say the conclusion which the tribunal came to, the burden of proof on all the primary foundational issues, was correct. But on a wider basis, which may not be necessary for the decision in this case, but may be regarded as being of wider importance, we submit that any throwing of the burden of proof in penalty cases, in relation to what we describe as the foundational facts, is not compatible with Article 6.2 and represents an unjustifiable interference with the right to a fair trial and Article 6.2 in particular. And as my Lord Justice Singh rightly suggested yesterday, given the criminal nature of the penalties, particularly given their amount and their effect upon the taxpayer and his reputation, the court will have to consider, and the tribunal have to consider, and it's something which will have to be done in every case, whether or not an interference with the right is justified. We make it clear that our submission is not that there aren't circumstances in which it would be justifiable to impose a burden in relation to some issues onto the taxpayer. But in the present case, in relation to the foundational facts, those circumstances did not arise. And given the present constitution of the court, we say this with some diffidence, that our submission is any dictum which says that on any appeal against penalties imposed by state bodies, which were imposed in this case upon the basis of what HMRC assessed as tax due, to say the burden of proof as to liability is always upon the taxpayer, goes too far and isn't justified by the European cases or the cases in the Court of Appeal. So if I can start by moving on to the European jurisprudence, and the court has clearly had to deal, the European court has had to deal with cases arriving from different statutory regimes, different factual situations. But there are, as we've seen, a number of statements of principle which can be found which are of general applicability. Happily, in terms of brevity, they were largely considered by this court in Eurowines. And so can I take you to that? You've already looked at it to a degree, but I want to look at it in a little more detail. It's at page 504 in bundle 2 of the authorities bundle, sorry, behind tab 29. Now, it's important we submit that the court understands precisely what the issue was which was being examined, because it isn't, with respect, quite as simple as was advanced by my learned friend. This is the case in which Lord Justice David Richards, as he then was, examined the law through a number of European cases. And if we can go to paragraph 1, please, of his judgment, first of all. He identified the issue as follows. This appeal raises one issue. Where a penalty is imposed on a person in possession of goods, of which it's alleged that excise duty has not been paid, is the reverse burden of proof upon whether the duty has been paid incompatible with Article 6.2. So the foundational fact is that the taxpayer must be found to be in possession of the goods before there can be any question of a reverse burden. And paragraph 4, his lordship said this: on an appeal to the first tier tribunal, the burden of proving the duty has been paid on the goods lies on the appellant. And then quote section 154(2) of the Act. But it's the burden is proving that the duty has been paid. So in other words, the taxpayer is found in possession of the goods, and then it's reasonable in terms of Article 6.2 to say, well, you've got the goods, you say that duty's already been paid on them, you must demonstrate it. Being in possession of the goods prima facie attracts the tax. This is amplified by his lordship at paragraph 7. The effect of section 1542 on proceedings concerning a penalty under paragraph 4 is that the burden of proof is in part reversed. The burden is on the commissioners to establish that the person in question has acquired possession of goods or been concerned in their carriage, etc., that the goods are chargeable with duty and the excise duty point for the goods has passed. We say the same is true in this case. The burden is on the appellant to establish that the duty has in fact been paid. So that's important we submit, because it's important to frame or see the factual background against which the subsequent discussion of reverse burdens was framed. It was framed on the basis that the foundational facts had to be proved. At paragraph 15, his lordship went on to consider the case of Salabayaku against France. We've already looked at this, but the citation quoted in paragraph 15 makes it clear that contracting states who wish to impose presumptions have to do it within certain limits and must be confined within reasonable limits which take into account the importance of what is at stake and maintain the rights of the defence. The rights of the defence in this case was for someone to say, you say I'm liable to penalties of £34 million. What is the factual basis for that? You need to prove at least that I supplied them within the duty system. That an allegation that I did so is simply not tolerable in a judicial system where so much is at stake for me. Again, paragraph 16, Janosevic against Sweden is considered, and his lordship summarised it this way. The court rejected a complaint that the imposition of tax charge was incompatible with Article 6.2. Under Swedish tax law, a penalty could be imposed on a taxpayer who submitted incorrect information to the tax authority. The penalty was 40% of the tax that would have not been collected if the authority accepted the incorrect information. The imposition of the penalty did not depend on any intent or negligence on the part of the taxpayer. And here we are. The burden of establishing that the taxpayer had supplied incorrect information lay on the tax authority.
That's under Swedish law, presumably.
Under Swedish law.
Yep.
But looking whether a reverse burden was appropriate, those foundational facts were relevant. And if one then looks at paragraph 18, again repeated the need for proportionality to the legitimate aims sought to be achieved. If I can take you, please, to Janosevic, it's volume 2 of the authorities bundle at page 514, and if I can take to page 549. Now, I did interrupt my learned friend briefly, asking the court to look at paragraph 98 of this judgment. The court first observed that administrative courts examining the applicant's appeals against the tax authority decision have full jurisdiction in the cases and have power to quash the impugned decisions. The case is to be examined on the basis of evidence presented, and it's for the tax authority to show there are grounds under the relevant laws for imposing the tax surcharges, and just to show that's not rooted in the individual laws of Sweden. If one just looks at the preceding paragraph, paragraph 97, it's clearly an examination of what paragraph 2 of Article 6 actually entails. If I can then go on to paragraph...
Sorry, can I understand what you're saying there and how that works?
I'm saying that if one looks at paragraph 97, one can see that what is being discussed is Article 6, paragraph 2.
So can we just, let me just be absolutely clear. So we start in paragraph 98.
Yes, so
Court
start
first observes that the administrative courts examining the applicant's appeals against the tax authority's decisions have full jurisdiction. So just pause there. Are you saying that the court is there stating what must be the case under the European Convention, or is it, on the other hand, recording what is the case in relation to Swedish tribunal systems?
It's there recording what are the powers of the Swedish tribunal.
Yes, I see.
But then we would submit that this then goes broader if one looks at how it goes on to talk about the cases to be examined on the basis that it's for the tax authority to show there are grounds under the relevant laws for imposing.
So let me understand that. Is it again referring to what is the position under the Swedish system, or do you say it's stating a general principle of what must be the case?
We say it's stating a general principle.
Now, why would that be? If the previous sentence is talking about Swedish law, why would the next sentence be stating a general principle?
Largely because looking at other cases, it's entirely in line with them.
I mean, yeah.
I understand the point my lord's making, but I think we'll see there's a unity in the cases which this reflects.
When it says there are grounds under the relevant laws must be the laws of Sweden, mustn't they? On the tax one?
Well, yes, so they have to show that under the relevant laws there are grounds for imposing the tax surcharges.
Yes.
In other words, there's a law that says you can do this, and then the tribunal, the tax authority, has to show those grounds are made out.
I mean, I'm not in the least. I'm not seeking to contradict your suggestion that this is all borne out by other things. But when you go to the third sentence, moreover, there is no indication that the members of the courts examining the applicant's appeals in the tax assessment case have prejudged. It's talking again about what's happened in this case, isn't it?
It's moving from a wider principle and then saying, moreover, in this case, there's no evidence that there was any unfairness in terms of prejudging. That had been one of the suggestions made by the taxpayer.
But one might have thought that if the first sentence deals with this case and the third sentence deals with this case, they won't have been trying to state a general principle in the second sentence.
Well, I say I hope I'll be able to demonstrate that.
Yes, from
by
other
the other cases.
Yeah. I mean, on the face of it, 98 says, well, this is what's happened in this case. And then in 99, they say, however, the applicant has complained.
Well, then we'll look at paragraph 100.
Yeah.
Which is in our submission of assistance. In respect to the applicant's first contention, the court notes that Swedish tax surcharges are imposed on objective grounds, that is, without any requirement of intent or negligence on the part of the taxpayer. As the court has previously held, the contracting state, so we go on to general applicability here, clearly may, in principle, and under certain conditions, penalise a simple or objective fact, as such, irrespective of whether it results from criminal intent or from negligence. So there is a power to penalise a simple or objective fact. The fact that's described as an objective fact rather does suggest it has to be established. Otherwise, it's a rather subjective fact. So the steps would appear to be, therefore, that firstly, inaccuracies are found in a tax assessment, a matter which the state has to prove, and then it's then presumed the inaccuracies are due to an inexcusable act on the part of the taxpayer, unless he rebuts the presumption. Now, what the court decided in Janosevic was that the presumption in those circumstances was a legitimate one, but at no stage was it suggested that it's not necessary for the state to prove the facts which are necessarily prior to the operation of a presumption. And we submit the opposite was the case. And then if we can return to Euro wines.
Just pausing there. I mean, one might almost think it should be the other way round. That there should be no presumption where you're alleging culpability, and yet that's all right.
One might say that, but before you can get onto culpability, you have to go into liability. You can't show something's deliberate, etc., unless you can show there was an obligation in the first place.
Yeah.
And we'll see in Khan, for example, Lord Justice Carnwath, it was axiomatic. He seems to have found that the fact of evasion had to be proved by HMRC. And in order to prove evasion, you have to prove a liability in the first place. That one can't be done without the other, we would submit.
Yeah, you were going to take us back to Euro wines.
I was. I think I've actually dealt with most of what I wanted to deal with. Would you just give me a moment? So if one goes to paragraph 32 to 34 of the judgment on page 511, behind tab 29, volume 2. One can see some of the matters which Lord Justice Richards felt militated in favour of the reverse burden of proof in the circumstances, as I repeat, that being in possession of the dutiable goods was admitted. The context is important. Paragraph 34, although the penalty is treated as criminal for the purpose of Article 6.2, it's essentially a regulatory penalty which is not dependent on proof of any fault on the part of the trader. Just pausing there, that clearly was at no stage the case being put against Mr Malde and the companies. They were saying this was deliberate fraud. It does not involve an immoral or social stigma. Clearly, it does in this case. And we'll come to rather more of Sheldrake in due course, because again, the facts are important. But he goes on to say this was considered relevant by Lord Bingham in Sheldrake's case, where at paragraph 21 he referred to the importance of what is at stake. This refers back to what he said about absolute offence at paragraph 6, Referring to offences found in legislation regarding the conduct of economic and social life, Lord Bingham said at paragraph 6, offences against such regulations are often regarded as not truly criminal, since the penalty inflicted is not dire, and little or no stigma attaches to conviction. This may be said, he said, to apply with greater force in a case such as the present, where the penalty is not, as a matter of domestic law, criminal at all. Well, looking at this in the broad, given the size of the fine, given the stigma, it clearly was. Paragraph 35, he felt that it was relevant that the class of persons on whom the penalty may be imposed are traders in duty goods. But that is predicated again against them having to come into possession at a dutiable point of the goods, caveat emptor, as it were. So again, if we go finally to paragraph 42, one can see again underlying his conclusions with the fact that the primary foundational fact was not in dispute. In circumstances where the evasion of duty is a long-standing problem with serious consequences for the public finances, it is, in my view, reasonable and proportionate that some burden is cast on traders to take reasonable steps to satisfy themselves that duty has been paid, and the essential words on stock purchased by them. So, the court has to examine whether the altered burden of proof is reasonable and proportionate. Looking at the way the cases are examined in Eurowines and at Eurowines itself, it wasn't suggested that the state merely has to make the allegation for the taxpayer then to have to shoulder the burden of disproving it. And in fact, the very fact that the court spent a lot of time in deciding whether a reverse burden could be justified rather suggests that it was accepted the initial burden of proving the foundational facts would have to be upon the state. So if I can move next, please, on to King and Walden. This is in Authorities Bundle Volume 3. Behind divider 36. And it's page 702. Now this is quite a difficult report to get to terms with because it quotes and replicates extensively the findings of the decision of the lower tribunal, but it's a decision by Mr. Justice Jacob. It is from 2001, and it comes from a time where HMRC was still disputing that penalties were criminal in nature and engaged in Article 6. So quite a lot of the considerations relate to that. The statutory provisions were different, and the court was having to grapple with whether previous determinations in the course of this particular case could be challenged, or whether they were determinative, and the claim or the appeal centrist around interest payments. The court had to consider the effect of Section 101 of the Taxes Management Act 1970, which you can find at page 755. foot of the page, and then on page 756, for the purpose of the preceding provisions of this Act, as part of this Act, any assessment which can no longer be varied by any commissioner on appeal or by order of the court should be sufficient evidence that the income or chargeable gains in respect of which tax is charged in the assessment arose or received as stated therein. Now that's gone now, that provision, as I understand it, no longer in force and certainly played no part in the present case. But the effect of it was that in that case assessments were taken as good, and the judge decided that they'd be taken as good unless the taxpayer could show that they were wrong. If I can take page 761 and the judgment of Mr. Justice Jacob.
Sorry, page.
Page 761.
Yeah.
You can see at the foot of the page, having recited the arguments, he says this: in my judgment, the system of imposition of penalties for fraudulent or negligent delivery of incorrect items, so incorrect returns or statements, is criminal for the purposes of 6.2. And then he sets out the reasons for holding. At E, the final part of paragraph 71, he says this: it's accepted that generally, leaving out of account section 46.2 and section 101, it's not for the taxpayer to show the determination of penalty was wrong. On appeal, the burden of proof lies on the Crown. In this regard, there's a clear distinction between a penalty determination and an appeal against an ordinary assessment, where the burden of showing it was wrong lies on the taxpayer. So he was quite clear where the burden of proof lay, and he returned to it, paragraph 81, in practical terms. The suggestion on behalf of Mr. King is that to the extent the penalty appeals took into account the primary facts determined by the 1991 commissioners, i.e. the previous determination, the limited presumption created by section 101, there was a shift in the burden of proof. I do not agree. I think these matters amount to no more than the evidential case against Mr. King. The true legal position is that the ultimate so-called legal burden at all times lay on the revenue. The 1991 facts and the 101 presumption, which itself arises from primary facts, form part of the evidence against him. Look at it another way. There's no matter giving rise to the penalty determination which the revenue have not at one point or another had to prove. So to say the burden of proof was cast upon Mr. King makes no sense. So we say that, again, this is unequivocal.
Yeah, but then we have to look at the terms of the statutory provision pursuant to which the penalty was imposed.
Yes.
And doesn't that involve a requirement on the revenue to establish negligence? Or I may not remember that correctly, but where do we find the actual? Was it in section 95 of the 1970 Act? Go back to paragraph 68. Mr. Underwood is distinguished the Georgian case. And it says the penalties in this case could be imposed for negligent as well as fraudulent conduct.
Yes.
I mean, that's what the revenue had to establish, that the conduct was negligent and fraudulent.
Yes.
Which again, I think is common ground. I mean, if that is what the legislation says, the position now would on any event on the revenue's case lie on the revenue. Because that's part of the superadded structure, so to speak.
Well, it is, but how do you prove negligence?
Well,
It can only be negligent failure to do it if there was an obligation to do it. So the foundational facts
yes, well, it may be
are
in
a
that
necessary precondition.
maybe in that situation, the revenue would have to accept the burden of establishing the, as you call them, the foundational facts, because
Yes.
that is the only route.
Yes.
I'm not saying it is, but the argument would be that is the only route by which fraud and or negligence can be established.
Yes.
But that's quite unlike cases of the present type we're concerned with, where there's, or at least not quite unlike, but the analogue in the present case is the requirement to prove that conduct was deliberate. As opposed to is perhaps compared to the underlying question of whether there is.
Sorry, Mulder, that's one of the questions
In one of the contexts.
the court has to examine, or the revenue have to examine.
Yeah.
But the foundational fact before any liability can arise, and before any questions of negligence, if you had to show negligence or culpability or whatever, but liability itself has to be holding the goods, supplying the goods, selling the goods within the UK. We just don't go anywhere without that being proved.
Can we just get back to paragraph 81 for a moment? So I'm trying to understand what it
81,
means.
sorry.
Paragraph 81, what paragraph are you looking at? When Mr Justice Jacobs says there is no matter giving rise to the penalty determinations which the revenue have not at one point or another had to prove, what does he mean?
I understood that to mean that going through all the issues in the case, HMRC had proved the individual ones.
So if we take, on your case, a foundational fact would be the liability to pay tax.
Yes.
So when did the revenue have to prove that?
I may need to come back to that, as I say. It's a very, very lengthy,
I mean,
very lengthy report.
they obviously assessed under section 101 that could presumably no longer be varied,
Yes.
but is the judge proceeding on the basis that the assessment is having to prove your foundational fact?
Would you just give me a moment? I'll get to the.
Or is it as possibly an alternative view? Well, that wasn't really what they had to prove. They had to prove negligence or fraud, and the judge wasn't thinking about proving the underlying liability.
I think probably, given that there had been a determination back in 1990 or 1991, which the judge held was persuasive, was relevant as evidence, but that you couldn't block the taxpayer from challenging it. It may be that reference back is to what had led to the determination in 1991. But if I may, we'll
Sorry.
I don't want to.
No. So probably I'm just going to confuse myself and everybody else. But if you go back then to the 1991 events, which I haven't done,
No.
What did that involve? Was that an appeal by a taxpayer against an assessment, or what happened in 1991?
It was an appeal against assessments.
Yes, I see. So
Paragraph 4.
yes, I see. So there was an appeal against assessments, and the appeals were dismissed.
Yes.
But
In
at
fact,
that stage, because they were appeals against assessments, the taxpayers will necessarily have had the burden of proof.
yes, if one looks at paragraph 5 on page 747, one can see how penalties became relevant. Mr. King unsuccessfully appealed the 1991 decision to the High Court and the Court of Appeal. Shortly after the High Court decision, the Revenue informed him that the imposition of penalties was contemplated, and then they issued the penalty in due course.
So trying to understand the sequence, the revenue assess, the taxpayers appeal, they lose,
Yes.
presumably under section 101, they can no longer be varied, I don't know. But at no stage have the revenue have borne the burden of proving the liability, because it will have been the burden on the taxpayers to challenge the assessments.
As assessments.
As assessments, but nevertheless the judge proceeds on the basis that that's all right. So he proceeds on the basis that as regards your foundational fact, is all right, even though the revenue have never had to prove it in terms of having the burden of proof upon them.
We'll have to look again at it.
Yes, yeah, and I've only just glanced. Haven't got the sequence properly in my mind.
Its opacity is to which we ought to pay tribute, like so much tax law, in fact.
I'm afraid it's not an easy case either to find one's way around or to
No.
necessarily follow.
No, it isn't. But if we may, we'll perhaps do a very short note on it overnight, just so that
would be very useful, I think.
when I say we will,
Walls are dropping behind you.
yes, yeah. So can I move then on to Khan and Lord Justice Carnwath's consideration? It's I'll primarily look at it in fact through the Upper Tribunal's consideration of it. So if we could go to core bundle page 101. So reading from paragraph 97. The only penalty case in the line of cases to which Mr Hayhurst refers is Khan. The case involved appeals by the taxpayer, Mr Khan, against the decision of the commissioners for HM's Customs and Excise that his taxable supplies had been above the VAT threshold. The consequence, he should have been registered for VAT against the best judgment assessment. The appeals raised various issues: unfairness at interview, breach of Article 6, the hearing of appeals before the tribunal, burden and standard of proof, and irrationality. So far as the burden of proof was concerned, the commissioners had not disputed the burden was on them to prove Mr Khan had acted or admitted to act for the purpose of evading VAT, and his conduct involved dishonesty. His argument was that Mr Byrne was also on the commissioners to show that the VAT threshold had been exceeded, and for the purpose of the penalty calculation, that the best judgment assessment was correct. The commissioners conceded the burden of proof lay on them not only to show that Mr Khan's supplies had exceeded the registration threshold, but also establish the quantum of tax evading. So just pausing there, we will go to look at little parts of Khan. But this was noted by Lord Justice Carnwath that both parties agreed that the foundational fact that the threshold had been exceeded had to be proved by HMRC. But he wasn't content to accept that joint approach. And so his comments have to be seen set against that background as far as having heard appropriate argument is concerned. In the Court of Appeal, Lord Justice Carnwath wasn't content with analysis of the parties and explained what I just said, then supplied his own analysis. And he said this, and this is the broadest interpretation. The general principle, in my view, he said, is that where a statute gives a right of appeal against enforcement action taken by a public authority, the burden of establishing the grounds of appeal lies on the person appealing. Now, our submission is going to be that in fact, not only is too broad, but when you look at his actual reasoning, his reasoning doesn't support that broad assertion. So it probably would be better now, I'm afraid, and perhaps I should in the first place, to go to the report of Khan itself, which is in volume 2, tab 31.
Page number.
562, sorry, 562. So, this was a case in which the owner of a dry cleaning business wasn't registered for VAT, HMRC carried out investigations and concluded he'd exceeded the threshold. And if one looks just below letter H and the head note, what one sees this. During the course of correspondence, the taxpayer admitted more books have been used than the number initially relied upon.
Sorry, I see, yes.
Yes. And so he admitted, as it were, having hidden some books from HMRC. So if we go in Lord Justice Carnwath's judgment to paragraph 70 and the succeeding paragraphs. Paragraph 70 is the one where he set out the general, his analysis of the general position that I just referred to. He then cited other statutory contexts in support of that. In paragraph 71, he cited a couple of planning cases. And at paragraph 72, he said it's true that both Nelsonville and Hill were planning cases, but the statements in the former are expressed quite generally. There may, of course, be something in the nature of an appeal or the statutory context which requires a different approach. And talks about the Transport Tribunal, then says this. The ordinary presumption, therefore, is that it's for the appellant to prove his case. The approach seems to me the correct starting point in relation to the other categories of appeals with which we're concerned under Section 83 of the 94 Act, including the appeal against a civil penalty. The burden rests with the appellant, except where the statute has expressly or impliedly provided otherwise. So no consideration at this stage of Article 6. Thus the burden of proof clearly rests on customs to prove intention to evade VAT and dishonesty. In addition, most cases of proof of intention to evade is likely to depend partly on proof of the fact of evasion. And for that purpose, customs will need to satisfy at least the tribunal the tax threshold has been exceeded. There is the precise calculation of the amount of tax due, in my view, the burden rests on the appellant. And then in paragraph 74, something we say is particularly important in understanding the underlying assumptions. This view is reinforced by a number of considerations. The appellant knows or ought to know the true facts. Section 67 makes express provision placing the burden on customs in relation to specified matters. So he's considering, of course, the dishonesty provisions. This suggests that the draftsman's sword is an exception to the ordinary rule and seems inconsistent with an implied burden on customs in respect of other matters. The distinction was also readily defensible as a matter of principle. Mr. Young relied on, quote, the presumption of innocence, unquote, under Article 6 of the Convention, but he was unable to refer us to any directly relevant authority. Pausing there, one might find that somewhat surprising.
Can we just pause there together, if you don't mind? I find that not only surprising, but potentially quite worrying.
Yes.
About what the status of this authority is.
I agree.
Given that there had been concessions made, Lord Justice Carnwath expressly said we haven't had full argument about this. We know that by the date of this judgment, in 2006, there was quite a body of case law already in Strasbourg, like Salabiaku. There had been a number of decisions of the House of Lords by this stage on reverse burdens of proof. Keberley was way back in 2000, I think.
Yes.
At the very beginning. In fact, I remember being counsel in the case. It was before the HRA was even brought into force. We'd had Sheldrake. Now, I was looking at the list of authorities cited in the law review. Case was referred to in judgment, so I'll be corrected if I'm wrong, but I don't see Salabiaku, Sheldrake, Kettering.
It's,
So I speaking for myself only, I'm quite concerned about what is going on here. About because it's not the judge's fault. Counsel was unable to refer us to any directly relevant authority. There were authorities.
this is my point. There are many relevant authorities, some of which we've already looked at. And there was discussion, and I'll come to it in relation to Article 6, but in a very different context. What was being raised, if my recollection serves me right, is issues in relation to the adequacy of representation, which may be ironic in the circumstances, and also the conduct of the interview. I think I've got the right case. So, yes, it is unhelpful that on an issue that the parties have been in agreement in, without citing and having cited to him the appropriate authorities, he then made broad statements of principle, which frankly really very difficult to put in conformity with Article 6.2.
It's a decision of this court.
Yes.
So it's binding on us in principle.
If it's not obiter or per incuria. And learned friends already suggested in one case that didn't suit him that was the case. We would submit that as the case here. Although I know my Lord Justice Henderson has referred to it in passing in another case.
As indeed as my Lord Justice Newey.
Yes, yes. But it
awards drinks.
Indeed so. And it seems to us that this, and perhaps it's because I say with respect that the focus in tax case and the knowledge base isn't necessarily that of human rights lawyers. I say that with due deference, etc. But a focus upon all the cases, domestic Sheldrake, for example, and in the ECHR, about how you have to look at the burden of proof and shifting the burden of proof, etc. A focus on that was essential for a proper understanding of how these appeals should work. And it's almost gone by the board. And neither doorstep nor awards referred to Article 6 in the sense of engaging with it at all in the multifactorial exercise which should have been gone into when deciding whether or not a burden of proof upon a taxpayer was appropriate. And again, one might even in domestic law have problems with a broad assertion that all regulatory appeals, the burden of proof was on the taxpayer. All sorts of different regimes, and it needs a good deal of caveating in our respectful submission. And in fact, if one looks at the facts of this case, it wasn't necessary for what he had to decide on the burden of proof, because if one looks at paragraph, continuing reading where I got to, Mr Young relied on the presumption of innocence under Article 6 of the Convention, but was unable to refer us to any directly relevant authority. The presumption clearly justifies placing the burden of proof on customs in respect of tax evasion and dishonesty. Now, setting dishonesty aside for the moment, to prove tax evasion, the foundational fact of tax liability is an inescapable feature of proving tax evasion. You can't evade a tax unless you are liable to it. And so we submit that as far as the burden of proof is concerned, he clearly had in mind that we're looking at a reversal post foundational facts being established. But in any event, what he said in broader terms is not compatible with the European legislation and isn't compatible with Sheldrake.
Just pausing there again for a moment. I mean, I follow what you say more generally, but as the proposition that he's dealing with reversal post-foundational facts being established, I find very difficult to accept, because to the contrary, he seems to be saying, I'm dealing with the extra stage of evasion or dishonesty.
Well, I think dishonesty and evasion are, you may say that all evasion's dishonest, and no doubt is regularly stated in penalty letters. But a penalty can't apply unless you've evaded the tax.
Now you may say you can't separate them out, but I don't think that's what Lord Justice Carnbeth is saying here. He may be meaning it somewhere else, but at this stage, he's not saying, the burden's on customs in relation to tax evasion and dishonesty, therefore it's on them in relation to everything. He's saying the opposite, I think.
I'm trying to cut some slack in the sense that I've sought to identify that in the individual case, whatever he said about the wider approach, which for the reasons we've submitted went too far, was wrong.
Well, it's about you haven't explained why it went too far and was wrong.
Well,
Is just because of Article 6 or for other reasons?
Because before you can get to the stage of saying that a reverse burden is appropriate or a shifted burden is appropriate, you have to look at the European guidance. You have to look at the guidance from the House of Lords. You have to look at the necessity for unreasonableness and proportionality of departing from Article 6.2's broad rule, as it were. And that has to be done in the context of the relevant issues. And if you simply don't examine them at all, which we say is the case here, then broad assertions that it's always on the taxpayer are not sustainable and not in accordance with principle.
Just talking around it for a moment, would you accept that what Lord Justice Carnbeth is saying is where there's an appeal against a penalty, the burden is generally on the person appealing, but that's qualified at least in relation to Article 6 so far as evasion and dishonesty is concerned?
He was saying that Article 6 would clearly justify placing the burden of proof on customs in respect of evasion and dishonesty. It may be the case that we in these submissions have rather lifted the bonnet and looked under the hood, as it were, as far as what it's necessary to prove tax evasion. But these aren't simply theoretical matters. As a matter of everyday practice, as a matter of reasoning in terms of examining evidence and coming to conclusions and so forth. Conclusions of things such as, has tax been evaded? Logically, it cannot be arrived at without considering whether or not tax was due.
So on that thesis, I don't know whether to look at the specifics of this case or more generally, but on that thesis, really, in the context of a penalty appeal, the burden has to be on the revenue in relation to everything, does it?
In relation to proving the foundational facts, yes.
Well, what else would there be?
Well, then
I mean, the revenue, except they have to prove the additional facts.
Yes.
So you say really the burden's on the revenue in relation to everything.
I think you would accept that if, for example, a statute allows the taxpayer to plead reasonable excuse,
Yes.
well, would you accept that on that issue the burden can properly be placed on the taxpayer?
Well, it is, and we'll look at one or two cases where that's been done.
So it wouldn't, even if you're right, and I'm not for a moment saying that you are right, because I have no idea what the right answer is in this appeal. But even if you're right on your main submission, it would not necessarily follow that the revenue have to prove or disprove every aspect of the case. But what you do submit is that they do have to prove what you call the foundational facts existed.
Yes. And if we look at the example we've already looked at a revenue as an alcohol trader is found in possession of alcohol, then the foundational facts are that you have the alcohol, therefore you're liable for the duty, unless you can show it's already been paid, or unless you can show someone else is liable. So it's not imposing an unfair or impossible burden on HMRC, we submit, to say, get it past first base.
And in this context, just to try and make this a bit more concrete, because in that kind of example, presumably there would probably be just an admission.
Yes.
If you've been found in possession.
Yes.
But in the present case, there was a very live issue, as I understand it, about the location of the sale.
Yes.
Whether it was in the UK or abroad.
Yes.
You say, you're the state, you impose a penalty on me, alleging that I am liable to pay this tax. You prove it,
yes,
including the fact of where it occurred. Is that right?
Specifically the fact where it occurred, because unless you can show it was in the UK, there is no basis for tax. There's no basis for registration. No basis for duty.
But I just want to be clear that that's what you mean by the foundational
Yes,
facts.
Indeed so.
Even though, I think you concede that if this were an ordinary tax assessment appeal, the burden of proof would rest on the taxpayer.
That's as the law stands, yes.
And does it follow from that submission that the taxpayer would have an advantage if, rather than appealing against a tax assessment, they just sit back and do nothing and wait for a penalty to be imposed, and then they can make the revenue have to prove everything?
No, because the assessment would still stand if they hadn't appealed it.
Right,
The
because
assessment would be there. And then the appeal would be in relation to penalties. Now, the argument, it seems to me, and it's legitimate to say, that there is such a conceptual difference between a liability to pay tax and a penalty which can be imposed on the taxpayer, i.e. global in this case, but also imposed upon Mr Malde, who wasn't the taxpayer. In those circumstances, it's entirely reasonable to say that the liability element has to be proved by the state, and that I would submit that the vast swathe of human rights lawyers would tend to think that saying, well, we're going to fine you £34 million, you prove we're wrong, is a fundamental undermining of the presumption of innocence, because that's what has effect happened in this case.
Just picking up one minor point, back to Euro wines for a moment.
Yes.
Where you say it's analogous. In terms of the foundational factors you would describe it, I think, of being in possession of the goods, there isn't really a parallel with this case, is there? Because no one's assessing for being in possession. There isn't a separate assessment attaching to that.
I'm not sure I follow it.
Well,
We
well
would
here,
submit-
here, one of the Sintra companies potentially has a liability to tax, which is the subject of an assessment and can be appealed. And on a freestanding appeal, the burden is on the company. And then there's a question of whether that should be followed through into the penalty. There's no similar first stage with Euro wines, is there? There's no separate issue as to whether there can't be a separate issue as to whether someone's in possession of the goods, because being in possession of the goods only matters in the context of the penalty.
I'm not sure, it's probably my fault. I follow that. They had to be proved, whether by evidence or by an admission, that they were in possession of the goods. This case, it has to be proved either by admission or evidence that Global supplied in the UK or held the goods in the UK.
Well,
I'm struggling to find a distinction.
and I follow the argument, but in this case, there is a separate question potentially in relation to each company as to liability, which can be litigated through appeals against assessments.
Yes.
There's nothing comparable in Euro wines. There's never going to be a separate assessment that's at issue in Euro wines.
No, no, it couldn't be an issue. Well, no. The liability to assessment was not at issue because they accepted being in possession of the goods.
But that was the only liability that could arise. There was no sort of separate liability that could be litigated. You were only going to be liable if you were in possession of goods and couldn't show that the duty had been paid.
Yes. As in this case, the company, setting aside the question of penalty, could only be liable in terms of tax if proved to be in possession of the UK or supplying in the UK.
Well, the company could be liable without HMRC proving that, because it was for the company to
Under
disprove
an
that.
assessment, yes, but I follow that. But if I remember rightly, it's been long enough to Euro wines. Yeah, Euro wines was a penalty case.
Yeah, no, quite. But there's no question of passporting in Euro wines.
No.
There's nothing to passport. It couldn't be.
Well, the company challenged the assessment on the basis that the duty had already been paid. They were saying duty doesn't arise. Yeah, I don't think there was no assessment, was there?
Well, no, this is the point. There could have been passporting in Euro wines. So say, for example, HMRC, because I said there was initially an assessment, an underlying duty points assessment for 370,000, as I understand it. That was then withdrawn. Then at a later date, there was the penalty assessment in the terms of millions. But what could have happened is you could have had a concurrent proceeding scenario. So say, for example, HMRC had issued a duty points assessment against Euro.
No, I see. Yes.
So
So
Euro wines. And then
you're correctly pointing out that I'm talking nonsense.
and then that was so the case of Tideswell, which is an FTT
Yes.
authority in the bundle. I didn't tell you that, but essentially that's an example of a duty points assessment, burden being on the taxpayer, and then that finding passporting through to the penalty.
Yes, I see.
So that passporting scenario, it could have happened because the same issue, I think, the same issue as to whether duty had previously been paid would have been relating to both, but it would have been resolved by the underlying assessment.
So, in broad terms, we say that the court should stand back and treat the broader statements in common with a certain amount of circumspection.
And just to be clear, do you say that there's a ground for disagreeing with them apart from Article 6?
Well, yes. In the sense that the broad statement that all appeals, the burden of proof falls on the appellant stroke taxpayer is wrong.
Because, I mean, he actually doesn't quite get that far. He says in general, doesn't he? But
Well,
anyway,
in general,
but why is that wrong?
because it's necessary in each case, and we'll look at Sheldrake. That's the next thing I'm going to come
You
on
mean
to.
because of Article 6?
It's because of
So,
Article
so I'm just trying to understand whether there's a point separate from Article 6.
Well, I think I made the point out that qualified, as your lordship said, by the preface in general, this is the position. The various regimes, etc., so different that making a statement like that is perhaps unhelpful.
Yes, I see.
I'm sorry to prolong this, but it may matter.
But it does.
We're the Court of Appeal,
Yes.
bound by another Court of Appeal decision, unless we can distinguish it or for some other proper reason. So can I just invite both of you, perhaps to help us overnight with a passage at page 582, which hasn't so far featured in your submissions on either side. And I don't want to set a hair running. If it's not relevant, just tell us tomorrow morning if that's the agreed position. Can I just invite attention to Roman 5 on page 582 of the bundle, where Lord Justice Carnworth refers to something we have been talking about at this hearing, which is what the relevance is of an earlier assessment and whether it's been appealed or has now become final. He even refers to what Mr Hayhurst has described as concurrent proceedings, where you have an appeal against a penalty at the same time as an appeal against the assessment. I'm not sure if that passage has any bearing on the issues we have to decide, but because neither of you has so far shown that passage to us, I simply invite attention to it so we can have your assistance.
My lord, just very briefly, of course, that section 60, doesn't relate to any of the 5 appeals in this case.
Well, that may be the answer. But
Yes, I mean, that relates to the Sintress A.
Can you just, if you wouldn't mind, and I don't want to take up time now, I certainly don't want to disturb the order of your submissions, Mr Webster.
Sorry, can I just find that up? Section 60 doesn't relate to anything in this case. 73.9, what does that say?
Well, it provides an assessed amount. Well, it's cited at 4th line down on page 582, perhaps to the extent that the court needs to look at it. Section 73.9 provides the assessed amount, subject to any appeal, is deemed to be an amount of VAT due. And so his lordship goes on to say, in a case where either there was no appeal against the assessment or the penalty proceedings follow the conclusion of such appeal, this provision would appear to preclude any attempt to reopen the assessment for the purpose of assessing the penalty. But that's not been relied upon in this case.
73.9 is the power to make a best of judgment assessment, isn't that? Is that right? Or I thought the wrong.
I think it's set out actually paragraph 8 of I think you're right, because it's tied to 73.1, which is the best of judgment.
That's right. So it's the best of judgment assessment is made, and then, if it's not appealed, it stands. Is really what he's saying, which is
Unsurprising.
which would follow from first principles anyway. It's a burden. We all agree. It's a burden on an assessment.
What I had in mind, and I don't want to prolong this discussion at this stage, but against letter B, it says the subsection does not apply directly here. Whereas here, the penalty appeal is combined with an appeal against the assessment. And the assessment is not therefore become final. It indicates another link between the two procedures, and he goes on to say, but you've read it. As I say, I'm not sure whether that passage is going to be of any relevance to the issues we have to decide, but it seems to be talking in part at least about what Mr Hayhurst has described as concurrent proceedings.
Yes.
You've said that on a penalty appeal, the HMRC have the burden of proving every element, including facts, that foundational facts which go to the liability question.
Yes.
And you may be right about that, I don't know. But it just occurred to me that passage may have something to say about. At the moment I'm finding it difficult to understand, but if I may respectfully say so, I find much of this judgment difficult.
I feel I'll be putting a nice press on my head by the time I get home.
I mean, at any rate, he must be thinking, well, look, 73(9) can't apply because there's a pending appeal.
Yes. Yes. So perhaps I could then just take you to Sheldrake, which is at volume 1 of the Authorities Bundle behind tab 19. And it's at page 259.
Once we've done this, we'll break.
I was hoping you were going to say that, I must confess. So it's
I'll find Sheldrake now. Which
Sheldrake. It's volume 1 of the Authorities Bundle. It's
Thank you.
the last one.
I got it now. Yep.
Last one.
Thank you.
So this is a House of Lords case, and it's important again when understanding the issues and the way in which they play out in relation to the drunk in charge of a motor vehicle. The argument was whether or not it was compatible with fairness and Article 6.2 to put a burden of proof upon a person to show that there was no reasonable prospect of him actually driving the vehicle. But it has to remember that that only comes into play if he's found to be in charge of the vehicle. I'm sure we all perhaps remember from many years ago doing criminal law, when you've been charged with a motor vehicle when you're sitting at home, as long as you've got the key in your pocket and so forth. So there are two issues. One, is he in charge of the motor vehicle? That is taken as read in this case. It's proved it's not in dispute. Secondly, is it right to put upon him the burden of showing that he wasn't going to drive it and there was no chance of him driving it? And so again, we say there's a similarity in the sense of foundational facts precede the question of a reverse burden of proof. And if we go to the passage from Lord Bingham's judgment, just give me a moment.
Would it be better to do this tomorrow?
I actually had the quotation from it. I was going to look at it through Khan, but so my reference to the paragraph.
Looking at what I've already marked, page 292
292.
has a much discussed passage. Paragraph 21.
That's the one. From the body of authority, certain principles may be derived. The overriding concern is that of a fair trial. A trial should be fair. The presumption of innocence is a fundamental right directed to that end. The Convention does not outlaw presumptions of fact or law, but requires that these should be kept within reasonable limits and shouldn't be arbitrary. It's open to states to define the constituent element of a criminal offence, excluding the requirement of mens rea. But the substance and effect of any presumption adverse to defendant must be examined and must be reasonable. Relevant to any judgment on reasonableness or proportionality will be the opportunity given to the defendant to rebut the presumption, maintenance of the rights of the defence, flexibility in application of the presumption, retention by the court of a power to assess the evidence, the importance of what is at stake, and the difficulty which a prosecutor may find in the absence of presumption. Security concerns, and one might say taxation concerns, do not absolve member states from their duty to observe basic standards of fairness. The justifiability of any infringement of the presumption of innocence cannot be resolved by any rule of thumb, but on examination of all the facts and circumstances, the particular provision as applied to the particular case. Now, that, of course, is from 2005, and Khan is from 2006. But that was binding.
This judgment is reported in 2005.
It's before that.
Judgment is 2004.
Yes.
And without taking time on it now, can I just invite attention to paragraphs 22 and following, where over a number of pages, Lord Bingham goes meticulously through each of the decisions which there had been in the House of Lords on reverse burden clauses. It goes all the way to paragraph 33. There had been about half a dozen decisions of the House of Lords, or in one case the Privy Council, and Scott. The only reason that was Privy Council was because at that time appeals from Scotland on human rights issues had to go to the Privy Council. They now come to the Supreme Court. So the only point I'm making is that by the time that Khan was decided,
Well established.
there were about half a dozen or more decisions of the House of Lords on reverse burden clauses and how you decide whether they're compatible with Article 6 or not. And whether it matters or not at the end of the day, I'm not sure. But none of that corpus of case law is referred to in Khan.
No. And the exercise isn't really carried out either. And in fact, if one looks at particular final words of paragraph 21, it's difficult to see how any broad assertion in the way that Lord Justice Carnworth made it, and which has been...
I suppose what could be said, and Mr Hayhurst has made this submission, I think, is that the decisions in the House of Lords, like Sheldrake, had all concerned core criminal law, whereas he submits that there is authority which says that where we're dealing with the present kind of case, a penalty in support of a tax regime, it's not core criminal law.
It isn't core criminal law, I would agree with that, but that doesn't really assist us in analysing what the appropriate consequences are from the nature of the case, which has to be examined, as Lord Bingham said. Each one has to be looked, or each set of circumstances has to be looked at individually. And I think I go back to what I said earlier on, even in core criminal law cases, £34 million is big money.
I think that is a bit of a jury point, if I may say so, because, I mean, the big money depends on the fact that these were transactions involving huge amounts.
Well,
Inherently so. And on the other hand, if an assessment were raised for the whole 30 million and was not appealed, then that would lead to liability. We all have to accept that.
That would lead to liability on the part of the company
On
to pay the
company.
assessment.
And this is where the point about what is the nature, as it were, for relevant purposes, what is the nature of the kind of ancillary penalty, which is imposed upon somebody who's a matter of law. Of course, it's not the company, but it's nevertheless a director who has basically treats it as an alter ego and uses it to carry out a business, no doubt of great profit. And in practical terms, as I was putting to Mr Hayhurst this morning, this may be the only realistic opportunity the revenue gets to actually get hold of the money, if not from the company, then from the director whose company it is.
That may be a rather slippery slope of reasoning with
Well,
respect.
I agree with that. I can see perhaps the possible appeal of that line of argument. Maybe we should be stern and resist it.
Well, in a sense, it goes back to the old saw hard cases make bad law.
Yeah, that may be right.
And at that, let's break for the night and reconvene at 10 tomorrow.
All rise if able.